-19197-FH People versus Michael Allen Kemp. This was set this morning for a summons on an alleged probation violation. It is my understanding from speaking to Ms. Holly, the probation officer, that at this point the amount stated in that summons has been paid and that we can dismiss the summons. Is that accurate, Ms. Holly?
Correct.
Okay. And so you are Michael Allen Kemp, correct?
Yes, sir.
Okay. All right. So, Mr. Kemp, it sounds like you're all set. We will dismiss this summons for probation violation because you paid. So you can go ahead and log out.
All right. Thank you so much.
Keep reporting like you are, and I'll process a discharge. Okay.
Yes, ma'am.
Okay. You still got to pay child support.
Yes, ma'am. I definitely will pay my support.
Okay. Thank you, Judge.
Thank you.
Judge, before you call another case, can you hear me all right? I was having technical difficulties last week.
Yes, I can hear you.
Okay, thank you.
Okay, the jail Zoom device is muted and the camera is off. Send a request to start the video. Okay. Okay, we're on the record in file 22-20927-FH People versus Derek Mitchell Baughy. We're here today for hearing on an alleged probation violation. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Baughy this morning, Your Honor.
And you know how Mr. Baughy would like to proceed?
Your Honor, I've had discussions with Mr. Baughy and with Ms. Walsh in this matter, Your Honor. And Mr. Baughy will be pleading guilty to count 1 of the probation violation, and count 4 will be amended to strike, cut off, and add remove to the tethered device, Your Honor. And counts 2 and 3 will be stricken. So it will be count 1 and the amended count 4. And that is with the agreement of the probation department.
That is correct.
Is that all right? And he also had a failure to appear at the first probation violation hearing. Do you know how he wants to handle that?
He will plead guilty to that as well, Your Honor.
All right. Mr. Baughy, would you raise your right hand, please?
Yes, Your Honor.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Derek Mitchell Baughy, correct?
Yes, Your Honor.
Mr. Baughy, you understand you have a right to contest the violation of probation charge and to have a trial on it?
Yes, Your Honor.
You understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, Your Honor.
You have a right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. You understand all of that?
Yes, Your Honor, I do.
On the other hand, you understand, or I'm sorry, you do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor, I do.
You also have the right to testify if you wanted to testify. Do you understand that as well?
Yes, Your Honor.
How do you plead to the charge that you violated your probation by removing your tether?
Guilty, Your Honor.
And I'm sorry, he's also pleading guilty to count 1, is that right?
Count 1, yes, Your Honor.
And how do you plead to the charge that you violated your probation by missing your curfew on June 17, 2023?
Guilty, Your Honor.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you'll be giving up any claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor, I do.
Judge. There's also
Yeah.
2 other dates in count 1 where he violated his curfew.
I'm sorry, okay. All right, Mr. Bauke, I mentioned with respect to count 1, the date of June 17, 2023. Are you also pleading guilty to missing your curfew on June 18, 2023, and also on June 20th, 2023?
Yes, Your Honor, I am.
All right, if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor, I do.
Is it your own choice to plead guilty today?
It is my own choice, Your Honor.
All right, so you were placed on probation in this case back in June of 2023, is that correct?
Yes, Your Honor, I was.
And as part of your probation, you had to do a period of electronic monitoring with the curfew, is that correct?
Yes, Your Honor, I did.
And were you late getting home on June 17, 2023 at 1:13 a.m.?
Yes, Your Honor, I was.
And did he also miss curfew on June 18, 2023 by getting home at 4:52 a.m.?
Yes, Your Honor, I was.
And did you also miss your curfew on June 20, 2023 by getting home at 1:17 a.m.?
Yes, Your Honor, I was.
The curfew was the result of a violation, Judge.
Okay.
He was initially placed on probation on 7/22 of 22.
All right, and Mr. Bauke, did you also remove your tether on or about June 28, 2023?
I did, Your Honor.
All right, I'll accept those pleas. They've been given understandably, voluntarily, and accurately. Mr. Bauke's had full knowledge of his rights. He's had competent counsel. I will refer the matter to the probation department for an update of your pre-sentence investigation and set sentencing for January 18th at 8:15 a.m. With respect to the contempt, Mr. Bauke, do you understand you have a right to a trial on that as well?
Yes, Your Honor, I do.
You understand that throughout that trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
You have a right, again, you'd have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, Your Honor, I do.
Again, you're not required to testify at your trial, and no one could say anything about you testifying or not hold that against you in any way. Do you understand that as well?
Yes, Your Honor, I do.
You would also have the right, again, to testify at the trial if you wanted to testify. Do you understand that?
Yes, Your Honor, I do.
How do you plead to the charge that you failed to appear for a probation violation hearing on June 26, 2023?
Guilty, Your Honor.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, Your Honor, I do.
Has anything been promised to get you to plead guilty to that?
No, Your Honor, it has not.
Have you been threatened in any way in order to get you to plead guilty to that contempt?
I have not, Your Honor.
If I accept your plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor, I do.
Is it your own choice to plead guilty?
Yes, Your Honor, it was.
So in this case, we had a summons that directed you to appear in court to respond to these probation violations on July 26, 2023 at 8:15 a.m. Do you agree with that?
Yes, Your Honor, I do.
And you did not, in fact, appear here for that hearing. Is that correct?
That's correct, Your Honor. Yeah, that's correct.
All right. I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Boyd has had full knowledge of his rights to have competent counsel. I will set this matter for sentencing on the same date, January 18th at 8:15 a.m.
I'm sorry, what date was that, Your Honor?
January 18th at 8:15.
Thank you, Your Honor. May I be heard as to bond?
All right.
Thank you, Your Honor. Mr. Bakke has continued during this process to pay his child support, Your Honor. He is working. I think that's perhaps the crucial part of his probation. I would ask the court to consider letting Mr. Bakke out pending sentencing, Your Honor, allowing him to get back to work and to continue paying on his child support.
Your Honor, I can make 2 more payments before I even have court. At least 2 more payments before I have court.
None of that's been verified, Judge.
I can bring verification in tonight before your office closes, Ms. Walsh.
You mean that he's working, Ms. Walsh?
That he's working or his payments have been verified.
My payments went to Michigan Disbursement Unit. I can verify all of that, Your Honor, by noon today, even if I'm let out of jail soon enough. I can verify all of that.
Hey, Judge, can I interject here? The last time we had him out on GPS tether, the tether was actually cut to where we actually had to recover the device.
I was using methamphetamines when I was doing all of that, and I'm clean right now as is. I've been clean for a while.
Yeah, Judge, I would ask for no bond in this. He clearly
All right.
missed a show cause and
Okay, so this is a second time that Mr. Boy has violated probation now. There's a prior violation that he pled guilty to back in May of this year that involved using methamphetamine and failing to report. And then this is an instance of removing a tether and not reporting for a period from June 28, 2023 to January 8, 2024, when he was arrested on a warrant. And so That's not a track record where I'm willing to do a PR bond at this time. And so I'm not going to modify bond pending sentencing. We will see you back, Mr. Balky, on January 18th.
Yes, sir.
Thank you, Your
All
Honor.
right. You can let the officer that's with you know that you are done with court for today.
All right, thank you.
All right, Ms. Underwood, I have, I think Brian Olds is here. I think he's your client.
Yes, Your Honor. Could I have a breakout with Mr. Olds?
All right, one moment. Mr. Mawad, are you there?
Yes, Judge.
Mr. Samuelson is here in person in the courtroom. Do you need a breakout session with him?
Judge, I've talked to him and I talked to Mr. Fleming last night about the case. So we're good to go whenever you're good to go.
Okay, give me just a moment. All right, Mr. Olds, I'm going to place you in a breakout session with Ms. Underwood.
Okay.
All right, Mr. Samuelson, if you'll come forward to the podium, please.
Do you, Judge? Or
To the podium.
that means right here? Oh, right here?
Yeah. Okay, we are on the record in file 23-21614-FH, People versus Timothy Preston Samuelson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Fleming.
Good morning, Judge. Chris Fleming, appearing on behalf of the people.
Your Honor, good morning. Elias Muwad appearing on behalf of Mr. Samuelson.
All right, and Mr. Mawad, where do we stand with Mr. Samuelson's case today?
Judge, I'm asking for one more date in March. Mr. Fleming and I talked yesterday. He finally was able to talk to the alleged victim in the case about her wishes. I think what we have to do is fine tune a plea offer. We have to run some guidelines. I do believe it's going to end up in a plea, Judge. I'm just asking for one more date. I know the case is getting old.
Mr. Fleming, anything to address from the people's side?
Nothing for the people's side, Judge.
All right. Let's go with March 6th at 8:15 a.m.
Okay.
Thanks for everybody.
And Chris, can I sign your name to the order?
Absolutely. Thank you, Eli.
Okay.
Okay,
right.
so
Thank you,
Mr.
Judge.
Samuelson, your next date is March 6th at 8:15 a.m. You can either come in person like you did today, or you can attend by video conference, and the bailiff will give you our video conference information.
Thank you, Judge.
Okay, thank you.
All right, Tim, I'll be in touch. Thank you. Bye-bye.
Thank you. Yes, you're free to go.
Mr. Fleming, we're having some difficulty with your audio. It's real quiet, and court recorder says she's not able to hear you through her system.
Is that a little better there?
That is better, yeah.
Perfect. Thank you, Judge. Sorry about that.
Okay, so. Mr. Bennett, you are here for Mr. Jones.
Thank you.
Yes, Your Honor.
He is not logged in at the moment. If you want to try to get in touch with him.
Yeah, I did reach out to him. I haven't heard back either.
Okay. Mr. Malero, we have Mr. Jenkins is here in the courtroom in person.
Okay.
Do you need a breakout session with him?
Yeah, if I could, Judge, that'd be great.
Okay, Mr. Jenkins, if you'll step into the hallway, there's an iPad there. And I will bring that into the meeting and put you in a breakout session with Mr. Malero.
Thank you, Judge.
Sergio, the camera's off and it's muted out there. Could you fix it? Maybe he's got it. Okay, one moment, Mr. Malero. We're having an issue with the hallway device. There we go. All right. Okay, Ms. Underwood, are you ready to proceed with Mr. Olds?
Thank you, Your Honor. Yes.
Okay, we are on the record then in file 23-21535-FH, People versus Brian Douglas Olds Jr. We are here today for a pretrial hearing in this case. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Ron Underwood for Mr. Olds this morning, Your Honor.
Okay, and Ms. Underwood, where do we stand with Mr. Olds' case today?
I have had discussions with Mr. Bayonetto, and I have been able to discuss these matters with Mr. Olds, Your Honor. At this time, I would like to check a couple things out. So I would ask for perhaps another pretrial in maybe 5 weeks, Your Honor, if that would be agreeable with the court.
The case at this point is 112 days since bind over, so I'm going to set it for trial. If you come to a resolution in the meantime, then we can address it then, but I can't wait another 5 weeks or continued negotiations or whatever it is that you want to do and then set it for trial at that time. So how long, Mr. Bayonetto, do you think you need for trial?
Should only be 1 day, Your Honor.
You agree with that, Ms. Underwood?
Yes, Your Honor.
All right. Ms. Clark, can you give us a 1 day jury trial date, please?
Would you like that back up to anything, Judge?
Yeah, that's probably all right.
Thursday, March 7th, we backed up to a 2-day jury trial.
That would work for me, Your Honor.
Ms. Underwood, does that date work?
I'm looking. I guess that would work, Your Honor.
So trial date on March 7th at 9 a.m. And we'll do a final pretrial on February 28th at 8:15.
Thank you, Your Honor.
Court will issue a scheduling order.
Thank you, Your Honor.
Okay. Thank you then, Mr. Olds. You can go ahead and log out.
Mr. Olds, call my
Yes.
office for an appointment.
Okay.
Thank you.
Okay, Mr. Malero, are you ready to proceed with Mr. Jenkins?
I am, Your Honor.
All right, Mr. Jenkins, you want to come forward? You can sit at the table here if you'd like. Okay, we are on the record in file 22-21198-FC, People versus Dakota Brian Jenkins. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. Malero. I'm sorry, with Mr. Hartung.
Thank you, Your Honor. Good morning. Doug Hartung for the people.
Salvatore Malero on behalf of Dakota Jenkins.
All right, and Mr. Malero, where do we stand with Mr. Jenkins' case today?
Your Honor, Mr. Hartung and I are very close to resolving the matter in a plea agreement. I would ask perhaps a 2-week adjournment so we could get that finalized.
All right, Mr. Hartung, are you in agreement with that?
Yes, that's fine, Your Honor.
So that put us at January 24th. So January 24th at 8:15.
That would be perfect, Judge. We'll have it all settled by then, I'm pretty sure.
Works for me. Thank you. Sam, give me a call.
All right.
All right, Mr. Malero, would the defender's office prepare a stipulation in order for that adjournment, please?
Yes, Your Honor.
All right. Okay, so Mr. Jenkins, you're all set for today. You'll need to be back here either in person or by video conference on the 24th. Okay. Mr. Malero, do you need a breakout session with Mr. Choate?
Yeah, if I could, Your Honor, that'd be good.
All right, Mr. Choate, give me just a second here. I'm going to put you in a breakout session with Mr. Malero.
Manor, I got a message that Mr. Glazier will not be available to 9:30, so I'll stop back around that time
Okay,
and we can all thank him for the heads up.
okay. Okay, we are on the record in file 23-21435-FH, People versus Kyle James Choate. We are here today for a pretrial in this matter, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record. Who do we have from the prosecutor's office that's handling this?
Somebody appeared on behalf of the people, Judge.
Salvatore Malero on behalf of Kyle Choate.
All right, and Mr. Malero, where do we stand with Mr. Choate's case today?
Judge, we're actively working on resolving his one remaining case. Some items occurred that were out of my control, so I'd ask if we could adjourn this a week so I get this finalized.
People have no objection to that, Judge.
All right, it's gonna have to be, I think, I can add one more next week. So let's do January 17th at 8:15 a.m.
Thank you, Judge.
And Mr. Malero, would the Public Defender's Office do a stip in order for that one as well?
Yes, we will, Your Honor.
Okay, thank you then, Mr. Choate, you are all set.
Thank you, Judge.
Okay, Mr. Malero, we're calling for Jonathan Gregory right now.
Hi, it's Kelly and Judge Olsevers. Could we have Jonathan Gregory in the room for the judge, please? Thank you.
Mr. Bennett, I'm sorry, did you have any communication with Mr. Jones?
I did, Your Honor, and I suspected he could be the iPhone attempting to connect. Said he was logging on.
Okay. All right, so I've sent a chat message asking him to connect his audio or start his video. I've sent a separate request through the app to start his video, and I don't have anything yet, so.
I'll mute and then call him again, Your Honor.
Okay, thank you. All right, for the gentleman that just joined the meeting, can you tell me your name?
Yes, Jason Ansel Crone.
Okay, 1 second, sir. Okay, Mr. Crone, let's see, Mr. Goldstein is not logged into the meeting yet, so I'm going to place you back out in the waiting room until he gets here.
Okay, sir, thank you.
Okay, Mr. Malero, do you need a breakout session with Mr. Gregory?
Yes, please, Judge.
Okay.
He is not answering. I suspect it could be because he's trying to connect, but I'm not sure.
Okay, we are on the record in file 23-21584-FC, People versus Jonathan Andrew Gregory. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Salvatore Malero on behalf of Jonathan Gregory.
All right, and Mr. Malero, where do we stand with Mr. Gregory's case today?
Judge, we're still in an investigatory phase of the case. I have been in touch with Miss Arnold about some evidentiary issues that may or may not have some bearing on the matter. So I'd ask if we could adjourn this out at least 30 days.
I've spoken with Ms. Arnold, standing in for her today, and we have no objection to that.
Okay. My notes indicate we were waiting for a criminal responsibility report. Has that been received? I don't have any. I haven't received anything.
I see a competency evaluation in the file. I don't see any request or order for criminal responsibility, but let me double check.
All right, maybe I misspoke. Let me go back and.
So, Judge, I'm looking at the file, but my recollection is were we seeking? Oh, yeah, it's according to the letter, it's in the process.
I'm sorry.
I remember now. I wasn't seeking a competency ruling. I was seeking a responsibility ruling. And apparently somebody put in a competency for some reason. But yes, we're also waiting on a responsibility determination.
Okay, I do see now in the file an order for evaluation relative to criminal responsibility that was entered on August 3rd of 2023. And so we're still waiting on that then.
Yes, I'll have my staff find out what's going on with it.
Okay. All right, I apologize, Mr. Miller. You were asking for an adjournment, but I don't recall how long you were asking for.
I think 30 days would be okay, Judge.
Okay, let's go with February 14th at 8:15 a.m.
Thank you, Your Honor.
All right, and again, Mr. Malero, can your office prepare that stip in order?
Yes.
Okay, Mr. Gregory, you can let the officer that's with you know that you are done with court for today.
Thank you, Your Honor.
Okay, and then Mr. Malero will call for Mr. Hollis next.
Thank you. Your Honor, could I have a right now with Mr. McCready on Mr. Hollis? I think that's his case.
It is.
Yes. Yeah, give me just a second here.
Thank you. Bye.
Okay, good morning, Mr. Dagger Margosian. You're here for Jenny Justice.
I am.
Yes. She is not logged in if you want to try to get in touch with her.
I did.
I'm sorry, did you say you have?
Yeah, I already have. With no luck.
Okay. All right, we are on the record in file 23-21619-FH, 23-21620-FH, and 23-21621-FH. People versus Jenny Mae Justice. We're here today for pretrial conferences in these cases, and we are proceeding today by video conference. Courtroom is also open to public. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Fleming. Are you appearing on this one?
Yeah, that's fine, Judge. Chris, I'm going to be on behalf of the people.
Your Honor,
And Mr. Dagger.
Michael Dagger Margosian for Miss Justice.
Record should reflect that this was set for a hearing this morning at 8:15 a.m. It is now 9:03 a.m. Ms. Justice is not present here in the courtroom, and she's not logged into the Zoom session. Mr. Dagger Margosian, anything you would like to say with respect to her appearance this morning?
Well, Your Honor, the only thing I'll say is that we waived the preliminary exam in district court as Ms. McClure and I had constructed a pretty good resolution on this case. Ms. Justice indicated to me that that was acceptable. She was in court. She was out on bond. She was in court with me. So it's a little out of the ordinary for a defendant in this situation to not appear. So I would just ask the court to take that into consideration if and when Ms. Justice does show up to the court or contact me or however that happens. But it was like I said, we waived the exam in anticipation of entering a plea, and these cases would be resolved. So I just want the court to know that.
All right. I would indicate with respect to the 23-21619-FH file, it does appear we have an outstanding warrant for her for testing positive for methamphetamine, amphetamine, and cocaine in a drug screen that was collected on December 6th, 2023, pursuant to her bond conditions.
And Judge, after that positive, she is not drug screened at all. So 0 drug screens from December 6th after.
All right, so it is failure to appear at this point. Flipping through the file, looks like her first failure to appear. So what I'm going to do is give her the 48-hour grace period, but at the end of that grace period, issue a warrant for the failure to appear as well. And I would set bond on that warrant. In the amount of $10,000 cash or surety.
Thank you, Judge.
Thank you. Mr. Malero, we have Mr. Hollis here now. Do you need a breakout session with him?
Yes, Judge.
Hollis, give me just a second here. I will put you in a breakout session with Mr. Malero.
Yes, sir, sir.
I apologize, Mr. Hollis. I wasn't able to understand what you said.
Yes, sir. Yes, sir.
Okay.
just emailed Jerry Coley.
Yeah.
She had emailed conversation with Mr. Goldstein.
Your Honor,
Yep.
I don't know how much longer you want to wait on Mr. Jones. I've made 9 phone calls to him. My legal assistant has made 3 phone calls. He's not answering at this point. Is there something else pending? Because I think we might have seen something, but I haven't received notice of it.
He has a show cause up for today for testing positive for cocaine on December 18. And according to the affidavit filed by Mr. Coates, that was confirmed with the lab.
So we, in all honesty, I had, not me, actually, my legal assistant caught that appeared to exist. I actually contacted Ms. Arnold, who said she didn't know what it was. And she couldn't find it. I hadn't heard back from her, but I kind of suspected that was the case. So if you'd like, I suppose we can call it. I did speak to Ms. Arnold, and we were going to adjourn it out for a resolution proposal, and we're still missing the exam transcript.
All right, let me call it then. Clear on the record in file 23-21615-FH and 23-21616-FH, People versus Maurice Leroy Jones. We are here today for pretrial conferences in both of those cases, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the People, standing in for Allison Arnold.
Morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing on behalf of Mr. Jones.
All right, and the record should reflect this matter was set for a hearing this morning at 8:15 a.m. Mr. Jones is not present in the courtroom, and he is not, to my knowledge, logged into the Zoom session at this point. I do have one device that is logged into the Zoom session. The screen name is simply iPhone. The audio on that device is not connected. The video on that device is off. I have sent several requests, both through the chat function and through the separate ask participant to start a video button on Zoom to get whoever that is to start their video and connect their audio. I've received no response. Mr. Bennett, my understanding is you spoke to Mr. Jones at some point this morning, and he indicated to you that he was going to log in. Is that accurate?
Yes, I spoke to him, I believe, around 8:30, and he indicated that he was logging in.
All right, obviously we have no way of knowing whether in fact that is Mr. Jones or not.
I will say that I am aware that he does have an iPhone.
All right. I would also state for the record, we do have up for today, in addition to a pretrial conference, an order to show cause. Mr. Jones was ordered to show cause here this morning, why he should not be held in contempt for failure to comply with his bond conditions as a result of a positive drug screen from December 18, 2023. Anything else you'd like to say with respect to Mr. Jones at this point, Mr. Bennett?
Yes, Your Honor. First of all, my legal assistant noticed the hearing on the show cause. We have received nothing. I don't know whether Mr. Jones was personally served with that order to show cause today. When my assistant discussed it with him, he didn't know what it was. And I had spoken with Ms. Arnold on Tuesday night, asking what this was. She wasn't aware of what it was. I hadn't heard back from her. We did discuss the case, and we in our office discussed with Mr. Jones that we were going to be seeking an adjournment today to get enough time to obtain transcripts, and Ms. Arnold is going to put together a formal offer. Mr. Jones is aware of all of that.
Yeah, the violation notice was actually mailed to Mr. Jones, first class mail, 8 days ago. If you'd like for me to send you a copy, I'll be happy to do so.
I suspected that it could have been a test. I now understand that it was a positive test on December 18th. I just don't know if he had notice of it or not. He didn't seem to when my legal assistant talked to him.
Okay, I believe he's on Zoom right now. I think I just saw a picture of him.
All right, so are you Mr. Jones?
Yes.
All right, so Mr. Jones, we've called your case, and we were set today for a pretrial conference and also for a hearing on an order to show cause related to a positive drug screen. Have you received a copy of the motion in order to show cause, Mr. Jones?
Think so.
I'm sorry, I didn't understand what you said.
I said, I think so.
All right. The motion in order to show cause alleges that you violated your bond conditions by having a positive drug test on December 18, 2023 that was positive for cocaine and confirmed by Millennium Labs. The maximum penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the right to be represented by an attorney on this. Mr. Bennett obviously represents you on the underlying cases. Do you want him to represent you on this as well?
Yes.
All right, Mr. Bennett, do you want to speak to Mr. Jones, or how do you want to handle it?
Actually, Your Honor, what I'm going to ask is you to enter Mr. Jones to stand mute to the charges. I'm actually going to be asking for an adjournment in the underlying case, as well as these motions in order to show cause. I would like to see the actual motion in order. Is it Mr. Cost? Mr. Coast, I apologize.
It's Coast, that's fine.
Coast, okay. I apologize for mispronouncing.
If afterwards, if I can maybe get your fax, or if I could get your email, I'll be happy to send that to you.
Yeah. So I would ask that they all be put over, I think, to February 7th or 14th.
All right, so we'll enter a not guilty plea for Mr. Jones on the contempt, and I'll adjourn the pretrial to February 7th at 8:15 a.m. Mr. Bennett, would you prepare a stipulation in order for the adjournment, please?
Yes, Your Honor. And okay, I see you saw it, Mr. Coast. Thank you.
You're welcome.
All right, and I apologize, Mr. McCready, was there anything that we needed to address today from the people's side?
No, Your Honor.
Okay. All right, I think we're all set then, Mr. Jones, you can go ahead and log out.
Thank you, Your Honor. I believe that's the only thing that I have today.
Okay, thank you very much.
Have a good day.
Sir Malero, are you ready to proceed with Mr. Hollis?
Yes, Your Honor.
Okay, we are on the record in file 23-21407-FH, People versus William David Hollis. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
Salvatore Malero on behalf of William Hollis.
All right, and so this is a final pretrial in this case. So Mr. Malero, where do we stand with the case today?
Well, Your Honor, what I would like to do is confirm next week's trial date, and then go see Mr. Hollis tomorrow to see if this matter can be resolved. Mr. Hollis, however, has indicated to me something different, wants to address the court with respect to him obtaining different counsel. So that's where this case stands, Judge.
All right. What is it that you would like to say, Mr. Hollis, with respect to obtaining different counsel?
Mr. Malero is not doing his job, period. I'm sitting here, I'm here on a contempt of court, and I've been here for 6 months. I'm already bonded out on everything else. I'm up here, I was never arraigned on any home invasion, ever. Not on a first degree home invasion, ever. I was never arraigned on it. I'm already over, I invoked, Van Dusen invoked my 6th Amendment right to a fastest fee. It's over 180 days. It was already over my 21-day ruling. I've never been arraigned on these charges. Plus, I'm bonded out on everything else but a contempt of court, and I've been here 6 months on it. I need new counsel because he ain't doing it. He hasn't done anything he said he was going to do. He's working against me because this is my 6th Amendment right. I was never arraigned on any charges. I was never even arrested on a felony. I was arrested on a felony illegal entry. I go to a bond review, they change it to a 2nd degree home invasion. I go to a prelim on it, invoke my 6th Amendment right, get upstairs, they amend it to a 1st degree, put me upstairs, I get upstairs, they arraign me on a 2nd degree, now I'm going to pretrials on a 1st degree. They've been doing this to me all year.
Judge, if I may.
I'm only here on a contempt of court now, I'm bonded out on everything else.
All right, Mr. Malero.
Yeah, so Your Honor, preliminary examination was conducted. I have the transcript. I reviewed it to determine if there was any basis to file motions. I determined there was not. He was bound over on a 1st degree home invasion. My notes say, and I recall doing his arraignment. And then he did have a contempt allegation of which was set for, has been pushed off along with the rest of the case, of which he has a bond he has not posted. And this matter is set for trial next week. I don't understand why Mr. Hollis keeps focusing.
Mr. Hollis, I'm going to ask you not to interrupt and allow Mr. Malero to finish what he's saying.
Continues to focus on what he's just indicated to the court, but that's the only thing he focuses on. And so, you know, that's where we're at. And I might add, Your Honor, the prosecutor has made I think, a very generous and reasonable plea offer that I was going to discuss in further detail with Mr. Hollis tomorrow.
All right, well, let me deal with one thing before that. All right, so Mr. Hollis, your case was bound over from the district court on June 23rd, 2023 on a charge of first-degree home invasion. Court records indicate that you were arraigned in circuit court on July 5, 2023, at which time you pled not guilty to that charge. So you have been arraigned on this charge and you pled not guilty to it. And we have set it for a trial.
Sir, is there any way I can get the contempt of court dropped? I've been here 6 months on it.
I'm not just going to drop the contempt of court. The contempt of court refers to a bench warrant that was issued for a failure to appear back on August 2nd of 2020.
I've been here 6 months on it, so. Bonded out on
I'm sorry, I wasn't able to understand what you said.
Sir, I was bonded out on everything else. I've been here 6 months on the contempt of court, 93 days.
Well, it's not just a contempt of court, it's that you violated bond conditions in this case. And so it's not simply that you're there for the contempt of court, it's that we gave you an opportunity to be out on bond on your home invasion charge. You didn't, according to the warrant, comply with your bond conditions. And so we're holding you so that we can deal with the contempt of court, but also so that we can move forward to have a trial in this case, which is scheduled for January 18th. And so to the extent that you requested or made an allegation that Mr. Malero has been ineffective for failing to address those issues, I don't think that he has. You have in fact been arraigned on the home invasion charge, and he has proceeded to try to resolve the case, and short of that, we've scheduled it for a trial. So Mr. McCready, what is the offer that the people have made to resolve the case?
We're open to resolving this through mental health court.
All right, so I need to know what does that mean? It requires a plea to the as charged, or what is the offer?
Well, that's as far as we've gotten with the discussions. It would probably be a lesser offense. I'm willing to adjust the offense to make it so that it qualifies for mental health court. But he hasn't been willing to even discuss that up until this point.
All right, well, we are 8 days before trial at this point. That is the situation. There is a plea agreement deadline in this case of January 17th, which is the day before trial. I won't accept any pleas after that date. Because if we get to trial date and a jury comes in, we're going to move forward and we're going to try the case as charged.
Understood, Your Honor. I'm going to speak with them tomorrow in depth.
Have proposed voir dire questions and jury instructions been submitted?
I did submit those, Your Honor, yes. I don't believe that there's been an objection to what I submitted.
All right, is there any audio, video information that's going to be used at the trial?
Yes, we do have body-worn camera footage that I'll be using.
All right, I would just ask Mr. McCready and Mr. Malero if you're going to have any that you come to the courtroom the day before and just hook everything up and make sure it works.
very well.
Thank you, Judge.
All right, we're all set for today then, Mr. Hollis. You can let the officer that's with you know that you're done with court for today.
I also asked to talk to the FBI, and they wouldn't even let me talk to the feds or an investigator at all. And I've asked to talk to both of them.
I can't, there's the microphone there is
I
bad.
asked the officers here several times. I needed to talk to an investigator, and I had to talk to I asked them to get the FBI over here from Monroe, and they wouldn't do either one of them either.
How does the FBI relate to this case, Mr. Hollis?
So I need to talk to an investigator.
Well, I'm not going to get into why, but you need to explain to me why that is relevant to what.
Like a lot of crimes are being committed against my family and me. They're not allowing me to talk to the feds. They're not allowed. They're controlling my mail, my everything. So, did you receive any letters I wrote you?
I've not seen any letters that you've written to me, Mr. Hollis. You are not allowed to communicate with me ex parte, meaning outside of a hearing and without the presence of the attorneys. So I don't know what the FBI has to do with investigating and proceeding with this matter to trial. So we're going to proceed. We're going to proceed next week, Mr. Hollis. You can let the officers know that you're done with court.
Thank you, Judge.
Mr. Malero, they have Mr. Marshall here in person from the from MDOC.
Yes, Judge, if the court recalls, last time we were in court, Mr. Marshall, well, I'm not sure exactly what he was doing, but he was ranting or something. And so Mr. Glazer is going to speak with him at some point and then decide if he's going to receive new counsel.
All right, are we able to accomplish that today? Because that's why we brought him here in person today.
Yeah, I wasn't aware I needed to talk to Mr. Marshall, but I can, I got to do 2 pretrials and I can come down there.
Okay, we'll call for Mr. Torres right now if you want to call for Mr. Torres, please.
Okay.
Thank you, Judge. Your Honor, I'm going to, with your permission, go over to Judge Anzalone's court now. Do you need me?
Okay.
She is waiting for you, Mr. Malero.
Thank you.
If you need me, you know where to find me, Judge.
And they did confirm Jerry Coley was adjourned to the 24th.
Do you want to ask them about Jason?
Yeah.
Okay, Mr. Glazer, do you need a breakout session with Mr. Torres?
Yeah, yes, I do, Your Honor.
1 second. Okay, we are on the record in file 22-20819-FH, 22-20820-FH, and 23-21668-FH, People versus Randy Torres. We are here today for probation violation hearings in the 22 cases and arraignment in the 23 case. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Hartung.
Doug Hartung, appearing for the people, Your Honor.
John Glazier on behalf of Randy Torres.
Okay, and Mr. Hartung, does Mr. Torres wish to have the information read in the 2023 case?
You asked that question of me, Your Honor. I think Mr. Glazier should probably answer.
Mr. Glazier, does Mr. Torres wish to have the information read?
No, we'd waive that, Your Honor, and enter a plea of not guilty at this time. Ask the matter to be set for a pretrial. I believe this matter will be resolved, Your Honor, but I don't have this particular file worked out yet, and that's not yours, is it, Doug? You said that's
the newer file is not mine. It's Mr. Sneed's. I can handle it today if you want to, but it's Mr. Sneed's file.
Well, Randy wants
the misdemeanor files belong to Mr. Bayonetto, I believe, John.
Okay, so you're just here on the VOP.
On the VOP today, and I can sit in on the arraignment if you want to enter a plea today, but I understand why you need to adjourn it one more time.
Yeah, I need to set a pretrial out. He wants to see me in person, and I'd like to make sure that I know exactly what we're dealing with here when I go down and talk to him.
All right. I'll enter a not guilty plea then for Mr. Torres on the 2023 case and set a pretrial for February 14th at 8:15 a.m. if that works for everybody.
That's fine.
What day was that again, Your Honor?
February 14th.
At 8:15, right?
Correct.
All right, I'll come down and see you before that, Mr. Torres.
Thank you.
Okay, thank you then, Mr. Torres. You can let the officer with you know you're done with court.
Thank you.
That's all I have for this morning. I gotta do one in front of the other judge, Your Honor, then I'll be down.
Okay,
said-
thank you, Mr. Glazer.
Yeah, what is Mr. Monroe's first name?
It's Tori Marshall is the person.
Tori
you
Marshall,
speak.
excuse me.
Yeah.
John, if you get a chance, come talk to me before you talk to Tori.
Why, you want to talk to me right now?
Just when you get here, you got another case to handle in Judge Anselmo's court. I'll be on the third floor.
All right, I'll be
Or the
down
second
there.
floor.
All right, thanks.
Okay, you will call for Bobby Brown, please.
Hello, it's Kelly again, Judge Seekers. Could we have Bobby Brown, please? Thank you. Bye.
Okay, Mr. Goldstein, I do have Mr. Crone here. Do you need
Yes,
a
sir.
breakout session with him?
No, Your Honor.
Yes.
Sorry, was that a yes?
Yes,
No, Your
sir.
Honor. No,
Okay,
he's
one
just
second.
responding. Okay, Jason, just hang on, okay?
Okay, we are on the record in file 23-21520-FH, People versus Jason Crone. We are here today for a pretrial conference in this case. We are proceeding today by video conference. Mr. McCready, are you appearing on this one?
Yes, I am, Your Honor. I'm standing in for Allison Arnold.
Okay, and Mr. Goldstein?
Your Honor, we had adjourned the matter to today because Mr. Crone has another matter.
Mr. Goldstein, I can't hear or understand what you're saying. Your microphone is muffled.
Is that better, Your Honor?
No, it is not.
I don't know what the problem is. Is it better now?
No, I can't understand what it is you're saying.
All right, I'm going to log out and log back in.
Okay. Okay, we have Mr. Goldstein back. Mr. Goldstein, you want to try saying something?
Hopefully you can hear me this time, Judge.
I can. It's very faint, and it's not going to be. We're not going to be able to create a very good record of anything. So, is there anything substantive that we need to do with this case today?
No, Your Honor. Let me leave this building. Give me about 30 seconds to leave this building. Once I get outside, it might be better.
I couldn't understand any part of that, Mr. Goldstein.
He said he was going to leave the building in give him 30 seconds.
Okay.
I'm outside now. Is this any better, Judge?
That is a little better.
Okay, good. I don't know what the problem at this end is, but anyway, no, what I was saying before is that we adjourned till today because Mr. Crone has a matter in district court. It was supposed to go to exam between Christmas and New Year's. And for whatever reason, it did not go. So Ms. Arnold and I think probably the best thing to do is to get that exam done and see what happens with that. Then we can address both cases if it gets found over at the next pretrial.
Okay. Do you happen to know the date of the exam now?
Not off the top of my head, Your Honor. I believe it's next Wednesday, but I'm not. If I don't have my calendar with me, so I can't check. But I believe it's next Wednesday.
All right. So let's set it then for January 24th at 8:15. If that happens not to work out, or that's not the date of the exam, you're free to contact the court or contact Ms. Clark and just set it for whatever date that it would be up here when the exam takes place.
I will do that, Your Honor. I'll get you a step in order for the 24th.
Okay.
Thank you,
all right.
Your Honor.
Thank you. Then everyone can go ahead and log out. All right, Ms. Underwood, you need a breakout session with Mr. Brown?
Just briefly, Your Honor, thank you.
How you doing today?
Good, thanks. 1 second, sir.
Hang on.
Okay, we are on the record in files 23-21572-FH, 23-21573-FH, and 23-21667-FH. People versus Bobby Jean Brown III. We are here today for pre-trials in the files ending 572 and 573, and an arraignment in the file ending 667. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready. Are you appearing on this one?
I can stand in, Your Honor.
All right, go ahead and put your appearance on the record, please.
Dave McCready for the people.
Ms. Underwood?
Rhonda do it for Mr. Brown this morning, Your Honor. Thank you.
All right, the 23-21667 file is set for arraignment. Does Mr. Brown wish to have that information read?
He would waive the reading of the arraignment. He would waive the reading, Your Honor. We would acknowledge the receipt of the information and the request for discovery and witness list, Your Honor. We would, at this time, request the court enter a not guilty plea on Mr. Brown's behalf. And I think, Your Honor, if we could just set these over to next week, that would give me a chance to talk to the prosecutor and see if we can combine some offers and resolve these issues, Your Honor.
I'll enter a not guilty plea on the 667 file and set a pretrial. I can't do any more next week, so we'll do January 24th at 8:15 a.m.
Thank you, Your Honor.
Ms. Underwood, would you do a stip in order for the other two files?
I will do a stip in order as to those files, Your Honor.
Okay.
With Mr. McCready's permission.
That's fine.
Thank
All right,
you.
Mr. Brown. Mr. Brown, you can let the officer that's with you know that you are done with court for today.
Yes, sir.
Call for different mix, please.
Kelly and Judge Osakers. Could we have Devin Rakes and room for the judge, please? Thank you. Bye.
he up here? I'm not sure.
I think he is.
Okay, yeah, I think he is then.
There's somebody.
Sergio will be right back.
Yeah. Sergio, as soon as he gets back, I'll let you back.
Don't get stressed out, all right? You guys are stressing me out. There's not two. I've been doing them and then I've been scanning as I go. Mr. Manager didn't put everything away for me.
Right. Yeah. Maybe. There we go.
Usually, it's not going to do a arrest, they'll get a PR bond and then more magistrate or do a court case, that's what we're the violation of condition of the bench. Like sentence, like probation. Probation, they consider about 10 days to get. Sure. Okay. anytime you need to.
Well, you know, I'm gonna yell at sometimes or not.
I won't yell at you. You gotta go, you gotta go.
I did. What's that? I don't know. I got a bad feeling.
That was just paperwork. I didn't search that down. It has the rest of the stuff.
Wake up. Just go say we're ready for you. You're up to it.
All right, Ms. Underwood, do you need a breakout session with Mr. Rakes? Ms. Underwood, are you there?
Yes, please, Your Honor. I apologize.
All right, we are on the record in files 21-20570-FH and 21-20656-FH, People versus Devin D. Rakes. We are here today for a probation violation. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Rakes this morning.
All right, and you know how Mr. Rakes would like to proceed today?
It's my understanding, Your Honor, that Mr. Rakes wishes to accept responsibility and plead guilty to the violation, Your Honor.
All right, Mr. Rakes, would you raise your right hand, please?
Yes.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Devin Dean Rakes, correct?
Correct.
Do you understand that you have a right to have a trial on and contest this violation of probation charge?
Yes, sir.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir.
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand that?
Yes, sir.
You are not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
I do.
On the other hand, you have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes.
How do you plead to the charge that you violated your probation in each file by failing to report on May 2nd, 2023, as you were ordered?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, but there are a few things that I would like to put on the record.
Okay, I'll give you a moment when the time is appropriate. But I just want to clearly understand, no one's promised you anything in order to get you to plead guilty. Is that right?
No, sir.
No, no one has promised you anything?
No.
All right, we're having some difficulty here. I'm just trying to create a clear record, and the answers are difficult to clearly understand if they're ever read in a transcript. So I'm going to just ask you one more time. Has anyone threatened you in any way in order to get you to plead guilty today?
No.
Has anything been promised to you in order to get you to plead guilty today?
No.
If I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir. I've had my own house about.
Okay, Mr. Rakes, give me just a moment. So you were sentenced in this case back in April of 2022 and given probation. Is that right?
Yes.
And looking at the file, has an order of probation in it that appears to have your signature from May 5th, 2022. Did you receive and sign that order of probation?
I'm not sure. Today?
No, back in May when you were placed on probation, did you get a copy of the order? Okay. Did you get a copy of that order and sign it?
Yes, sir.
One of the requirements in that order is that you report as directed. Is that right?
That is right, Your Honor.
And were you ordered to report on May 2nd, 2023?
Yes, sir.
And is it true that you did not report on that date?
It is true.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Rakes has had full knowledge of his rights and he's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation and set sentencing for January 19th at 8:15 a.m.
Your Honor, may I be heard as to the issue of bond?
Go ahead.
Your Honor, Mr. Rakes has a number of things that he very much desires to take care of. I believe he has animals and a house and things that Mr. Rakes, Are you there?
Yeah, I'm here.
That he
I'm
very
on
much.
the job. I've had a baby orange cat ever since I got him at 136 and a half South Main Street in Adrian. I've kept the same house the whole entire time from probation throughout. Probation has never tried to send me anything. They never came. I mean, is there any way I can get a cash bond to try to take care of my vehicle, get it out of impound and try to take care of my rent and maintain my vehicles?
Miss
I'm sorry,
Teskey
take
wanted,
care. I'm sorry. What is that,
Miss-
Mr. Wolf?
Agent Teskey is the agent on this. She wanted me to ask for no bond in this case. He did leave treatment and did not report after that as instructed, and he stated he was going to. Were you in drug court, Mr. Rakes?
Yes, I was.
Okay.
I did complete a lot of the drug court, and I got very, very far in it. I completed a lot of the things for it, the counseling. I completed all the drug testing. I just, for some reason, marijuana stayed in my system a long time, and I kept being accused of still smoking when I was still, and I was doing everything I was supposed to do, but they wouldn't phase me up simply because of that.
Okay.
And I didn't want to
Mr.
lose
Rakes?
my apartment.
Mr. Rakes,
Yes.
All right.
I don't think it's wise of you to make any further statements.
All right, so this goes back to the failure to report from May, and so it's about 8 months of failing to report in this case. And I think based on that, I am not going to change the bond or give a bond at this point, simply because I think that's what's required to make sure that Mr. Rakes is here for sentencing.
All right.
So, Mr. Rakes, you can let the officer that's with you know that you are done with court for today.
Can I speak with him in a breakout, please? And Miss Underwood, if she would like to join.
Sure.
All right, I apologize. I sent the wrong jail room to the breakout session.
Okay.
Hello. 1 second, Mr. Rakes.
Yeah, I forgot, we're supposed to get the police report and transcripts. I'm gonna leave it with him. We'll file this report. I don't.
Mr. Glazer, you ready to proceed with Mr. Marshall?
I am, Your Honor. I'd forgotten that we had him come in here in person. I think the reason was to give him discovery. And my secretary's bringing that over, but we can proceed before that if you want.
All right, well, if he's bringing that over, then I'd like to wait so we can remember now that we were going to do that on the record.
I forgot until he said that.
Yeah, okay. Yeah, could you call?
Okay, let's go to judges first. Could we have Derek King in the room for the judge, please? Yes. Thank you.
Okay, so we've called for Derek King. He will be here shortly.
How long is it going to take you to get this?
Thank you, Your Honor.
Anybody else? All right, thanks.
What's that? How you feeling?
Hi, you guys. Hey, guys.
Ms. Underwood, you need a breakout session with Mr. King?
I do, Your Honor. Thank you.
Yes. It is very good. Right.
Yeah. Hello? Leo? Oh, I thought you were ready. Just got a call from here. This has got the transcript with it? Yeah, it's a transcript. Okay, and the whole police report, right? Yeah. There were some subs. So that's it. Yeah, it's the last. Yes. Your Honor, I got the paperwork.
Okay, want to bring in Mr. Marshall? Sir, do you know if they printed him? I don't need them to do it before we have our hearing, but we just need to make sure they do it before they go back.
We have a TCN number.
Okay. Apparently we do have a TCN number, so that. The attorney over there. Okay, we are on the record in file 23-21498 FH People versus Tory Darnell Marshall. We are here today for a pretrial conference in this case, and we are proceeding today in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartson.
Thank you. I'm Doug Hartson, appearing for the people today.
John Glazer on behalf of Mr. Marshall.
All right, and one of the reasons that we are conducting the pretrial conference today in person is so that the Public Defender's Office can provide to Mr. Marshall copies of documents which there was some question or dispute whether had been provided or received. So we're just doing that on the record here today to ensure that Mr. Marshall has copies of those documents. So Mr. Glazer, what is it that you have there and what is it that you're doing to Mr. Marshall?
Your Honor, I instructed my secretary to print out all police reports and supplemental police reports. And he's told me he's done that. I also have the transcript, which looks like it was typed on November 9th of 2023. So it's a full transcript, 166 pages. And there he also ran a competency to stand trial, a separate report. I don't think there's a criminal responsibility with it. But that's what we have in our file with regards to discovery, and I'll give those to you.
All right, so record should reflect that Mr. Glazer is handing those documents to Mr. Marshall.
He might want to. We have like a folder or something. We can put those in there now.
We can find an envelope, I think. All right. The other issue was Mr. Marshall had raised the issue of whether Mr. Valero would continue to represent him. Have you discussed that with?
I have, Your Honor, and I think Mr. Valero is going to stay out. There's a couple things that Mr. Valero needs to, and you see that one typed up till November, so it would have to be filed after that. I'm going to instruct Mr. Valero that the client wants to have a motion to quash filed. In fact, if the court wants to set a date, I can make sure that it gets filed in time for that to be heard. And then after that, whatever Mr. Valero can work out, our client's going to have to decide whether he wants to take a new trial or try to resolve it some other way. So first thing we need to do is file a motion to quash.
Mr. Marshall, are you satisfied with that resolution and all of those issues today?
Yes, sir.
Okay. I don't know the court schedule for a motion hearing date, so I'll leave that to Mr. Malero to schedule that with Francis. Just give a call and get that scheduled.
Yeah, it shouldn't take long to prepare the motion. It's just a question of how quick the court can hear it. And hopefully that can be within the next 2, 3, 4 weeks. Okay.
We just expect that we'd be able to do it at some point.
Yeah, there wouldn't be any testimony taken or anything of that sort.
Okay. All right. Anything else we need to address today?
No, Your Honor.
Mr. Hart.
The court on its scheduling order set a pretrial in for next Wednesday. I think that was done by air. It's set up today. I don't know if the court wants to leave that on the schedule or not.
Yeah, I assume that was an error as well. I don't think there's any reason to have that. Again, I'll just leave it to Mr. Malero to schedule a motion hearing date and then leave that final pretrial on for April 3rd ahead of the trial date on April 11th.
Do you want to be? My client would like to be present in person for the motion hearing.
Okay. So we'll need then a little bit of lead time. When Mr. Malero gets that scheduled, he'll need to contact the prosecutor's office so that the prosecutor's office can prepare a writ so that Mr. Marshall can be here in person.
We need at least a couple of weeks advance on that, John.
Okay.
All right. Anything else for today then?
I'm all set. Thank you, Your Honor.
All right. Thank you. Then we're all set with this one.
All right.
Okay. Ms. Underwood, are you ready to proceed with Mr. King?
We are, Your Honor.
You're on the record in file 23-21419-FH, People versus Derek Eugene King. We're here for a final pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Fleming?
Yes, Fleming, appearing on behalf of the people.
Ron Underwood appearing on behalf of Mr. King.
All right, and Ms. Underwood, where do we stand with Mr. King's case today?
Your Honor, we've had discussions with the prosecutor, and the prosecutor has rendered 2 offers, such as they are, Your Honor. The first offer is that Mr. King can plead to as charged with a 3rd habitual and a sentencing agreement to no upfront prison in this matter, Your Honor. The second option is, as I understand it, that Mr. King can plead to a 2nd habitual, and there would be no sentencing agreement with that option, Your Honor.
All right, Mr. Fleming, is that an accurate statement of what the people have offered?
I believe it is, Judge.
And Ms. Underwood, is Mr. King wanting to avail himself of either of those?
Mr. King wishes to avail himself of the first option, Your Honor.
Okay, so the 3rd habitual with a sentencing agreement for no upfront prison.
Thank you, Your Honor.
Okay. Mr. King, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Derek Eugene King, correct?
Yes.
Mr. King, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, police officer assaulting, resisting, or obstructing with a 3rd habitual offender notice?
Yes.
And I'm sorry, I don't have, so we're gonna need an amended information with the 3rd habitual offender notice. And I'm sorry, Mr. Fleming, what impact does that have on the maximum sentence?
It will double the maximum sentence on those.
Double, okay. All right, so Mr. King, do you understand that that would make the maximum possible sentence in this case 8 years in prison?
That's good if I violate, right?
I'm sorry, I'm having difficulty hearing.
You saying, yeah, you saying yes, that you saying that's, but if I complete everything and don't get no trouble or nothing, it's disappeared, right?
Yes, you have a sentencing agreement that the initial sentence will not include prison time. But I'm required to tell you what the maximum possible sentence is. So, so do you understand that the maximum possible is 8 years?
Yes.
Okay, and is it also your intention to plead guilty to count 2, the 2nd count of police officer assaulting, resisting, obstructing, again with the habitual offender 3rd offense notice?
I didn't, I thought it was just the one offense thing that what they said that I would get the maximum penalty. Did that all run together? So that's what I thought.
Any sentence you would get with respect to both counts would be concurrent.
Okay, I just think, yeah, concurrent. Yes.
Okay. And so do you understand that just as with the first one, the maximum possible sentence would be up to 8 years in prison?
Yes.
I believe that one would be 4, Your Honor.
I would agree with 4, Judge.
Oh, I'm sorry. I apologize. So count 1 was causing injury. Count 2 did not have the causing injury. So I was mistaken there, Mr. King. So the maximum possible penalty with respect to count 2 would be 4 years in prison. Do you understand that?
Okay.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Fleming?
That is correct, Judge.
Ms. Underwood?
Yes, Your Honor, it is correct.
Is that also your understanding, Mr. King?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to have the witnesses against you appear at your trial, to be present at your trial, and you or your lawyer could ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. King, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
How do you wish to plead to the charge that on or about June 20, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer, causing injury?
Plead guilty.
Sorry, the microphone did not catch you there. Could you try that once more?
Plead guilty.
Okay, and how do you wish to plead to the charge that on or about June 20, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer?
I plead guilty. Yeah.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
That's correct. Okay.
I'm sorry, I can't, the microphone there is bad. Could you sit a little closer
Yeah,
to the device?
yeah. Yeah. No one wants me to do this.
Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. King to plead guilty?
No, Judge.
No, Your Honor.
Mr. King, other than as we've discussed on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
All right, Ms. Underwood, do you want to cover the factual basis?
Thank you, Your Honor. Mr. King, I take you back to June 20th, 2023. Were you riding your bike in the city of Adrian, County of Lenawee, State of Michigan?
Yes.
And while you were riding your bike, did officers Robinson and Castleberry try to get you to stop?
Yes.
Did they put on their siren?
Yes, eventually.
And they told you to stop, correct?
I couldn't hear them. I mean.
But you heard the siren and then
Yeah.
you knew they wanted you to stop.
Yes. Yes.
And you knew that they were police officers.
Yes. When I seen the car.
Who were performing their duties, and they were in a car and they were in a uniform, correct?
Yes.
And they caught up with you, and Officer Robinson tackled you, and when he tackled you, he was injured, correct?
Tackled me. I fell out.
Yeah, and he was injured, correct?
Yes.
Okay.
Yeah.
I believe the facts are established, Your Honor.
Okay, actually, according to the information, the causing injury charge related to Officer Robinson.
Mm-hmm. Yeah.
Is that? All right, I apologize. I thought I misheard you. Okay, Mr. King, do you agree that you were convicted on December 13, 2019 of the offense of possession of methamphetamine or ecstasy in Lenawee County Circuit Court?
Yes.
Do you also agree that you were convicted on September 22nd, 2016 of first-degree retail fraud in Washtenaw County Circuit Court?
Yes.
And you also agree you were convicted on January 30, 2014 of, again, retail fraud first degree, again, in Washtenaw County Circuit Court?
Yes.
All right. Mr. Fleming, I'm sorry, are the people satisfied with the factual basis?
People are, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D?
I believe you have.
Yes, Your
Ms.
Honor.
Underwood? I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. King has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement other than as has been placed on the record this morning regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for February 9th at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. King, then you can let the officer that's with you know that you are done with court for today.
All right, thank you. Thank you, Mr. President. Thank you all. Okay.
Thank you.
All right.
Thank you.
Okay, I believe that is everything.
Thank you, Judge.
Thank you, Judge. You have a good day here.
Thank you.